Good afternoon, everyone. So I see people are starting to join us. We are already at 18 participants. So Danielle, you can see then the people in the participants box. So we'll give people some time to join. Excellent. So we'll start in about a minute from now. Great, so we're at 12:35. Good afternoon, everyone. My name is Ina. I'm Director of Professional and Corporate Education at the School of Continuing Studies. I hope everyone is doing well today. We are very excited to have as our guest speaker today Danielle Miller-Olofsson, who is the Chief Privacy and Knowledge Officer at BCF. And today we will be talking about data protection in the age of AI and blockchain. So over to you, Danielle.
Thank you, Ina. Thank you very much for that lovely introduction. So as Ina said, I'm a lawyer and I work in the field of data protection. I've lived in Europe and I'm qualified to practice in Europe as well. And so I'm always sort of between two continents. And with Ina, we've put together a series of lectures that'll take place over the month of June on various aspects of data protection. So I hope you liked this and I hope you enjoyed it as much as I do, because I really enjoyed this. And we'll get started with no further ado. If there are questions, please feel free to ask them. There's the question and answer box on the screen, and I'd be really happy to answer questions as we go along. Otherwise, you can wait till the end. It's whatever works best for you. So, Ina has already introduced me, so I think we can leave that alone. Today, what I wanted to do was I wanted to divide the presentation into two parts. The legal part, the strictly speaking legal part of AI and blockchain and what legal concerns they raise. And then a second part that I find extremely interesting, if not more interesting than the legal aspects, and that is the ethical challenges that artificial intelligence and blockchain pose, because these are super exciting technologies. Everybody seems to be experimenting with them for a variety of reasons. And I really think that it's important as a society that we understand these technologies and that we try and put a framework around these technologies so that we're leading them and they're not leading us. And so that was sort of where I wanted to go in the second part of this presentation. So let's get started with the legal challenges. Now, just so that we're all on the same page, what I wanted to do is I wanted to define what I'm talking about. So I'm talking about artificial intelligence, and if you don't mind, I'm going to read a definition. I won't be reading my PowerPoint, but this is a definition that is sufficiently important that I get right. And so what it says is artificial intelligence, also known as machine intelligence, is a branch of computer science that aims to imbue software with the ability to analyze its environment using either predetermined rules and research algorithms or pattern recognition machine learning models, and then make decisions based on those analyses. In this way, AI attempts to mimic biological intelligence to allow the software, application, or system to act with varying degrees of autonomy, thereby reducing manual human intervention for a wide range of functions. So, artificial intelligence is equated with machine learning. It's dependent on algorithms, and it's also extremely dependent on data. It will collect a bunch of data, it will apply an algorithm to it, and reach a series of conclusions. Blockchain, on the other hand, is a very different technology. And what we're talking about here is a decentralized technology used to store and transmit information in a secure and transparent manner. What we're talking about with blockchain is a system that logs all transactions among its users from the very beginning of the chain. It's a secure and distributed ledger system. There are no intermediaries among the users. Transactions are grouped into blocks and validated by miners, and blocks are validated and time-stamped. Those are my two definitions. What I want to talk about today is that when you're using this technology, and this technology is using personal information, there are certain rules that apply. Now, personal information, it's very important to understand what we mean by personal information. Canada and Europe define personal information in a very similar fashion, and they define it as any information about an identifiable individual. And in this category, you can find things like IP addresses, be they static or dynamic, can be considered personal information. Information collected and stored in cookies can also be considered personal information. So it's not just your name, your address, your date of birth. Those are the obvious ones. It can also be your behavioral patterns online. This can also be considered personal information because it serves to identify you. And so when we're looking at that, it becomes really obvious that the kind of information that a lot of artificial intelligence is processing is personal information. Perhaps less so with blockchain, but still there is an element there. To go a step further, Europe has special categories of personal data, that they call it, and these are categories that relate to one's religion, one's gender, biometric information, one's union memberships, one's political beliefs. And in Europe, unless you have a good reason, you're not even supposed to be processing this particular information. So unless you fall into an exception, this is the kind of special category of information that we shouldn't even be processing to begin with. However, there are enough exceptions to justify the kind of processing that goes on. So it's not as if everybody's offside European legislation. That is not true. Europe and Canada differ quite substantially from the United States. The United States has a very different approach to data protection. It's not a less effective approach, it's just a different approach. And they don't define personal information in any one way. Generally, it's defined as an individual's name and either their first name or initial combined with their social security number, their license. Some states include biometric information, some states even include your mother's maiden name. But it is not defined in the same way across the board, and it can also depend on the sector in which you're dealing. Banking, not the same as health. So the United States, you have to really be careful as to which state you're in, which jurisdiction you're in. Is it federal, is it state, which sector you're dealing with. Now, that lays the groundwork for what we're going to be talking about. But one thing before I move on, personal information does not include information that is public information, and it does not include information that's been anonymized. So if you can truly anonymize your data, you will not fall under the various data protection regimes, be they in the United States, in Canada, or in Europe. One thing to be careful of is the definition of publicly available information. In Canada, even if information is on a website, it is not a website, pardon, a social media platform. If somebody's made it public, that does not necessarily mean that that information is considered public information. There's a very limited amount of information that's defined by regulation as to what's considered public. It generally includes newspaper articles, magazine articles, and we just haven't updated it, which is why the whole social media, that isn't considered public information. And that has certain ramification in the employment center. We'll see this in a different presentation, but if you're collecting information from sites, even if they're publicly, even if the settings are public, that does not mean that you're collecting public information. That information is still personal information, and so the data protection laws apply to it. Are there any questions so far? No, I don't see any questions. So I will go on to my next slide. Heavens. All right. When we process information, we have to do so according to certain principles. Now, these principles, one of the advantages of data protection law is that the fair information practices are pretty much universal. So they're going to be the same in China as they are going to be in Canada, as they're going to be in Russia, as they're going to be in Brazil, as they're going to be in Europe. And it's all a variation of a theme, which is really exciting because it means we're all talking the same language and we're all talking about the same things. It makes it very difficult for a country to go rogue and decide to develop their own data protection regime that's different and based on different principles. So that's one of the things that's amusing about this area of law. So when we talk about fair information practices, what are we talking about? Here I'm comparing the CSA model, which is the Canadian Standards Association model, and the OECD model, the model for the Organization of Economic Cooperation and Development. And basically they tell us the same thing. If you're processing information, you have to be accountable. And what that means is I'm an organization, I'm using somebody's personal information. I need to tell that person how I'm using that information. What am I going to be doing with your information? Who am I going to be transferring it to? How am I going to protect your information? And this is a principle that is becoming increasingly important for any business that is carrying out activities in Europe. There have been a series of judgments by the European Court of Justice that have come back and really hammered home the importance of accountability. Your privacy policies have got to be very explicit. It's not just a question of saying, okay, we do this, or yeah, we process your information. No, I need to know. I need to know if you're transferring it to Facebook, what Facebook's going to do with that information. So what we see is a tendency to really push for accountability. I have to identify the purpose for which I'm using your information. And that's an extremely important principle because it's at the basis of several of the other fair information practices. So I cannot just collect information willy-nilly for any old reason. I need to be very clear in communicating with you why I'm collecting your information. And even if you consent to my collecting more information than what I need to accomplish the purposes that I've identified, I can't process that additional information. So I really have to be careful when I'm identifying the purposes to properly define them and to take into consideration all the potential uses for the information that I'm collecting. Consent. Canada, we'll see in a minute, is a very consent-based regime. Europe is as well. But what that means is that if I'm collecting your information, unless there are certain exceptional circumstances, I really do need your consent in order to collect your information. Now, Europe goes a step further than that and says that it's not just consent. In Canada, you can rely on an implied consent, so it doesn't necessarily need to be, yes, I consent to X, Y, and Z. There can be a certain leeway if I'm using a site and I keep using activities, or I keep using different activities that are available to me on that site, even though I haven't said I explicitly consent. In Canada, that can be deemed as an explicit consent. In Europe, you have to consent clearly. And in order to do that, you must be informed as to different uses. Consent is an extremely touchy basis for processing, and we'll deal with that in the second part of this presentation. Another fair information practice that I touched upon earlier is I have to limit the collection of the information that I gather to what is strictly necessary to fulfill the purpose that I've identified. I can't just, as I said, collect all sorts of information in the hopes that I'm going to get to a specific result. That doesn't work. A good example of this is a case involving Winners and the holding company, where information was being collected. The driver's licenses were being collected when people checked out. Driver's license numbers were being collected when people checked out, because the store was trying to counter a practice that they'd noticed whereby people stole goods, and then return them for cash. And in order to prove that the person had purchased the good to begin with, what they were asking for was driver's license. Winners suffered a breach, and it was seen that they were collecting driver's license. And even though it was to prevent theft, the court still said, look, that's way too much information. You're collecting information that is not suitable to the purpose that you've identified. So that's an example of an overcollection of information. I need to limit the use, the disclosure, and the retention of the information that I collect. And this is really important, and it affects pretty much all of the companies that collect information. We can't keep information indefinitely, and nor do we want to keep information indefinitely, because as you'll see, the next obligation or fair information practice is that of accuracy. And the longer I keep information, the more difficult it is to keep that information up to date and accurate. So we really want, and it's in our interest, not to keep information forever. The other thing is, if you suffer a breach as an organization, it's a lot easier to notify 2 years worth of clients than it is 10 years worth of clients. It's a lot cheaper, it's a lot easier. So there are a ton of incentives to not keep data too long. I have to make sure data is accurate, and that's a really important one that we don't talk about a lot these days, but it is extremely important, especially I think in light of what's going on with the present pandemic and technologies that we're trying to develop to track the pandemic or to deal with the pandemic in some ways. And, you know, a tracking device that's accurate within 10 meters is not sufficiently accurate to tell me that I am at risk of catching this horrible disease. So it's not just good enough to grasp at straws. I do need to make sure that my data is accurate. Safeguards. I need to put in place safeguards to protect your information. I have to put in place administrative safeguards, which means policies. I have to put in place operational safeguards, and I have to put in place technological safeguards. I have to make sure that I have the passwords, that you're protected, that there are firewalls in place, and that I run constant checks to make sure that my safeguards are still working. Last few are pretty intuitive. Openness. I need to be open about the way that I use your information, and I need to provide you with the ability to have access to that information. And it can't be a complicated process. 18 months ago in Europe, there was one of the largest cases under the new data protection legislation against Google, which Google was fined 50 million euros because it was deemed that the way they'd structured their website wasn't sufficiently open to enable an individual to have the information they needed about how their information was being processed. So openness is extremely important. And then finally, if I'm using your information, I must give you access. You have to be able to say, okay, well, how are you using my information? What information do you have? Are you storing it? How are you storing it? And I have to give you the right to correct it if the information isn't accurate. I also have to give you some form of mechanism to challenge me. So I have to provide you with the name of my data protection officer as an organization, the person who you can contact if you're not happy about the way that your information is being processed. And then I have to give you also the name of the data protection authority in the jurisdiction in which you reside, so that if you're not happy with the way that I look after your information or process your information, you have to be able to go and ask for help from an outside body. So this was a bit long, I know, but these are the fair information practices that govern any way that we process information. Are there any questions so far? No. Okay. I'll move on to the next slide then. Now, when I process information, I need to have a legal basis. I don't just have to respect the fair information practices, but I have to base my processing on what we call the legal basis for processing. And again, what I want to do is I want to emphasize the fact that, as you know, probably rights are not absolute. In Canada, as in Europe, I have, as an individual, the right to protect my data, to protect my information, but a company also has the right to use the data in a way that is reasonable for the exercise of their business. Now, that doesn't mean they can do any old thing with it or collect any old form of information, but it means that there's a balancing act and that neither one side nor the other has an absolute right to do what they like with data. And the courts are absolutely adamant that this balancing act be maintained. So basically in Canada, as I was saying, if you want to process information, the legal basis for doing so is consent. I must make sure that I have your consent to process your information. Now, there are exceptions for law enforcement because it may not be practical to tell somebody that they're being investigated or that their information is being examined. Court procedures, these are very intuitive. To protect somebody's interest, I have an employee, they've just passed out. I can't be asking them for permission to give the ambulance, the coordinates of their home address or if they're next of kin or whatever. I have to be able to act. So there are exceptions. Certain laws allow for exceptions in the employment context. And then pretty much every law I've seen allows for exceptions for artistic, literary, scholarly, journalistic purposes as well. These are the legal basis for processing in Canada. In Europe, it's slightly different. Consent, absolutely. There are two legal bases for processing in Europe, and they're equally important. One does not trump the other, and it's important to realize that because as North Americans, we sometimes think, consent is more important. That isn't true. So consent is there, and it's the first one I wanted to mention. But also, there's what the Europeans call necessity. If you can prove there's a need to have the information you're processing, then you can go ahead and process it. And for instance, there's a necessity if you have to conclude a contract with a data subject. So what an example of that would be is I've hired you. I shouldn't have to go and ask for your permission to be able to have to deposit money in your bank account or to get your social insurance number. These are just pieces of information that I need to conclude our employment agreement. Likewise, if I have to fulfill a legal obligation as an employer, I have to remit certain information to the taxing authorities. I don't have to ask your permission to do that. That's a legal obligation that's incumbent upon me as an employer. So I don't need your consent for that. To protect the vital interests of an individual, that's the same as in Canada. If somebody's incapable of providing information and they need help, I have to be able to do that without any violation of the law. For the performance of tasks carried out by the person collecting information in their capacity as public interest or official authority vested in the controller and the person collecting information, I'm allowed to collect information in that instance. And then finally, if I have a legitimate interest, and that's this fifth bullet point is extremely important for businesses targeting Europeans or in Europe. I have the right to collect data if I have a legitimate business interest in doing so. And the European legislation is very clear that marketing constitutes a legitimate business interest. So I don't have to go and ask for your consent to collect information for marketing purposes. What I do have to do, however, is I have to give you the right to opt out if you want me to use your information for marketing purposes. But I am not prevented from using that information unless you tell me otherwise. And that's really important and really interesting. Now, a data subject has rights. These are rights that are reflected in the European legislation. Some exist in Canada, but not all of them do yet. It's anticipated that the Canadian legislation will change in the next little while and will begin to recognize all of these rights. There have been declarations by the government to that effect, so I'm basing this on something relatively concrete. I'm not just opining here. But what I mean by these rights are, I as an individual have the right to access the information that's being collected. I want to know what the company is doing, and I want to know what information they have about me. I have the right to rectify that information, be that a change of address or any other form of inaccuracy. I need to specify that because a right of rectification means, for example, if I'm an employee, I can ask my employer to see my file and have my address changed if it's no longer my real address. However, I don't have the right to have a performance evaluation changed, because a performance evaluation is the employer's assessment of me. I may not be in agreement with it. I may be, I think I'm the best employee on the planet, and my employer thinks that I have work to do to improve my attitude. That's not the kind of information that I can have rectified. It has to be sort of more factual. The right to erasure. Now, this is, in fact, the next 4 rights are rights that are recognized in Europe and not per se in Canada. The next 5 rights, excuse me. Right to erasure means that I can ask that somebody get rid of the information that they hold on me. And this extends even to internet sites. I can ask Google to take down the information that they have on me, and to contact a third party to whom they may have transferred that information. And that's a very, very important right. It's been recognized by the court in Europe in 2014. So it's fundamental. It isn't in Canada yet. There is some discussion about including that right. I can ask that information on me not be processed, or it can be only processed in a certain way, so I can restrict the processing. The right to be notified of the rectification on personal data or restriction of processing. It's just, I have the right to be informed when the processing of my information has been changed, the reasons and the purposes and the way of processing has been changed. And then I have the right to data portability. That's an extremely interesting one as well. And it's an extremely helpful one if you're a client or a customer. For instance, I am with a medical clinic. I'm not happy with that clinic. I want to change clinics. I want to change doctors. If my information is in digital form, I can say to that clinic, listen, I want you to transfer my file. That's it. That's the right to data portability. And the clinic has no right to block it unless they have a reason, a legal reason, which would be they fear that I'm going to take legal action and they need some backup. And then finally, there's a right to object to automated individual decision making. So if I know that decisions about me are being made by an algorithm, I can block that. This is in Europe. It's not here yet, but I think it's coming. Again, one caveat with respect to subjects' rights, they're not absolute. So if I'm a company and I've been asked to turn over all of the information on a person because they're invoking their right to erasure, okay, I do have to take down the information. I have to give them the information unless there's a journalistic purpose to justify keeping it, or unless I feel, or I fear rather, that I'm going to be pursued by that person and I need to protect myself and I need to build my case. So again, there's always a balancing act between the right of the individual and the right of the company. Neither is absolute. Do I have questions at this stage? Yes. All right, so somebody said when a user visits a site or uses an app, they're always asked to provide consent. Usually these terms and conditions are lengthy and hard to understand. Isn't this an issue? This is absolutely an issue. You're totally right to identify this, and it's an issue that I'm going to be addressing in the second part of this presentation. It's a great question. It's fundamental to our rethinking of data protection legislation right now. So I will go right. Now, this is my table of challenges that, artificial intelligence and blockchain pose to the various data principles and the various rights that we've been talking about. So remember at the beginning, I talked about artificial intelligence as a form of machine learning that uses algorithms, but it's also a form of machine learning that eats data. It is so dependent on data, and it's dependent on, I wouldn't say random sampling, but certainly a large sampling of data. And I don't necessarily know what the result will be when all this data has been crunched. So it makes it very difficult for me as a company using AI to be fully accountable in the way that we traditionally understand that data principle. How am I supposed to tell you from the outset how I'm going to use your information, what's going to happen at the end, what results I'm going to have? Sometimes the results that an algorithm produces are not the results that I set out to establish. And so it makes it very difficult when I'm using personal information to feed AI to really be truly accountable. Likewise, we get problems with the identifying purpose. I have an idea of where I want to go with this. Do I really know what my purpose of using this algorithm is? Not really. And so identifying purpose becomes a problem. Consent. The person who just posed a question has raised an excellent question about consent. How can you consent to necessarily to the use of AI? Do I really know what I'm consenting to? Not if I'm being told that the information is going to do one thing and in the end it does something else. So that's a hard one. Limiting collection, that just flies in the face of AI because I can't limit collection. The whole point of AI is that I have a lot of information that I can crunch. So no, I'm not limiting collection. Am I limiting use, disclosure, and retention? Retention can be probably yes. Disclosure as well, we can probably limit that, but am I limiting use? Not clear. And not clear if I don't know what my final objective is. What about accuracy? We're going to talk about this in the second half, but I have a lot of difficulty with this whole concept of accuracy and artificial intelligence. Much of it, not all of it, but much of it is garbage in, garbage out. I don't know if my data is clean. I'm basing decisions on raw material that may or may not be accurate, may or may not be biased, may or may not be a lot of things. But one thing is sure, not all of it's accurate. Safeguards is one I do think that we can protect, both blockchain and AI. Openness as well, I can tell people how their information is being used. Am I going to be able to give them access to it? That may be a little more difficult. And we see this with a lot of the, oh my goodness, a lot of the apps that are being, a lot of the apps that are being, I have a, okay. Sorry, I thought my microphone wasn't working, but I think it is. What about challenging compliance? How do I challenge compliance with blockchain and AI? That may not be as difficult a data principle to uphold. Right to rectify becomes complicated. Right to rectify becomes especially complicated when I have various levels. So if the processing happens at one level and then information gets shared at another, there can be various chains that are involved, and having to rectify all those changes becomes problematic. So I just wanted to mention, I will deal with blockchain in 1 second. I'm going to go through AI and then I'll talk about blockchain. Right to erase. The right to erase is difficult also, again, because of the multi layers that are involved. And what about when I'm using information for research purposes? I can say to a researcher, okay, look, I don't want you to use my information anymore, but what happens to all the studies that have been run on previous information? Do those studies get invalidated? Do I get to withdraw from those studies as well? It's not entirely clear. Right to restrict processing. You can exercise it. We'll see if it works. Right to data portability. Again, if information is being collected willy-nilly, it's very difficult to bunch all of the information that I have up in order to subsequently transfer it to someone else. And finally, the right to object to automated decision-making. I can definitely object to decisions being taken by AI. That's not a problem. But what happens? What happens to me after I object? So with respect to artificial intelligence, what I'd like to do is just to say that the biggest problems that I see with artificial intelligence are more the ones that we talked about at first. So that is the question of accountability, defining the purpose. obtaining consent, limiting the collection, ensuring that things are accurate, ensuring access also, as well as the right to rectify and the right to erase. Now, when I talk about blockchain, the elements that concern me more are not so much the accountability, identifying purpose, consent, limiting collection, accuracy, safeguards, and openness. It's more the second group. So the right to rectify. How do I rectify something on blockchain? The whole purpose of blockchain is to keep information in its original form. Now, there are ways of hashing and doing things like that, but it is fundamentally a technology that is defined, that's been developed so that I don't have to rectify, and that I do keep a record, and I keep an original record. That's the value of this particular technology. Compliance with blockchain. I check that as a difficulty because frequently blockchain transcends jurisdictions. So who's responsible for monitoring it? Yes, there are systems that are developed whereby it's self-regulating, but what happens when I have to go and enforce that? It's not clear anymore. The right to erase is the same problem as the right to rectify. The right to restrict processing, and the right to object to automated decision-making, fine. But if you don't want to do it, you've got to do it at the beginning of the process and not get involved in the process. It's very difficult once the process has started to invoke those rights. Now, I know that there are a lot of questions that have come up here, and let me just, sorry. So somebody has asked me, what about the right to be forgotten on the internet? Excellent question. That is a right that is recognized in Europe. It was a case involving, it's called Google Spain, and it is clear right that is recognized by Europe. It is not recognized on this side of the Atlantic yet. There is talk that it will be recognized in Canada. How does consent work on blockchain? You cannot erase data easily. Excellent question. I think that's what we were talking about, is that how does consent work on blockchain? Consent is very, on blockchain, you consent by entering into the processing. But as it goes, there's not a lot you can really do, as far as I know, to control it. And as to erasing data, there are discussions where people are talking about a form of de-indexation or hashing. But again, the record is there. So these are some of the areas that that are really affected by artificial intelligence and blockchain. And so what you see is that our data principles and the rights that these principles provide are severely challenged by things like by technologies like artificial intelligence and blockchain. And so right now, it doesn't matter what country you're in, we're all struggling with the same questions. How on earth are we going to develop artificial intelligence? How are we going to develop blockchain? And at the same time, respect what we have traditionally understood to be the principles of data processing. So with that, I'd like to go to the second part of this presentation and talk about some of the ethical challenges that these technologies raise. And some of you have already posed these questions. The first one is consent. Okay, so what is clear and enlightened consent? Europe requires clear and enlightened consent, which means that I have to know everything that's going to happen to my information in order to really consent to it. Fair enough. How do you consent to your temperature being taken by a satellite? I know it's up there, I know it's doing it. I didn't consent for it. I didn't consent that it do that. How do I consent on the internet to the processing of my information by a series of interconnected devices, the Internet of Things? How does that work? I don't even know that my car is talking to my water bottle, is talking to whatever, and what information they're transferring back and forth. Yet we think these are great devices, and they are great devices. It's just, how do you go and get consent for this? How do you get consent on devices that are so small? I can barely read a computer screen anymore with normal font. How am I supposed to read the consent form on something that's so small that I can't see it? How am I, as one of our members of our audience has raised, how on earth do I consent to a form that goes on for 10 pages? Is that even valid anymore? Or what about a form that goes on and has words that I don't understand? What if I don't understand the language in which it's written? What if I'm an immigrant to a country where I don't speak the language? That's happened to me. It's scary. So the whole idea of consent, I think, throws an awful lot of responsibility into the individual, and the individual doesn't control what's going on. So it's terribly unfair from a contractual standpoint to require that kind of onus be placed on the individual. And then what do we do in a situation like we're living now, which is a situation of a pandemic, where governments are pushing, rightly or wrongly, to develop applications that will help track and perhaps help counter the spread of a very frightening disease. Should it be left up to the individuals to consent as to whether they are or are not going to use these devices? Is there not a greater good at stake? I don't know. I don't have answers. I have my opinion, but I don't have answers to this. But what I'm trying to say here is that we have and we've developed our data protection models on consent and the importance of consent. And I think that it's very much, it is a principle that has outlived a lot of its usefulness. It's there and it's important to sensitize people to the fact that they own their data and they're responsible for it. But there has to be something stronger to protect data and to protect individuals than simply throwing everything back into their court and saying, hey, it's up to you to consent. I don't know if anybody wants to comment on that. I don't think so. Okay, we can move to the next. The second issue that concerns me with respect to big data and to artificial intelligence is, and I talked about this before, the accuracy of the data involved. If I am feeding a machine poor data, how am I supposed to get a good result? And there are also a lot of presumptions involved. I always use this example. I get every 2 years when I have to renew my driver's license, I get a letter from the License Bureau, from the Régie, and they tell me what great driving record I have and how my driving keeps streets safe. That's lovely and it's very flattering, and it's based on the fact that they've looked at my record and there are no accidents. But there are no accidents because I don't drive, because I'm a terrible driver and I hate it. And so it's a good example of how we make presumptions based on some of the information that we feed into a system, but the conclusion is a wrong conclusion. The reason there are no accidents on my record is because I hardly ever drive. It's not because I pay a lot of attention when I'm driving and I'm very, very cautious. It's not. I try and avoid it. And this brings me to the question of algorithmic biases. One of the cases to illustrate this that we saw recently-ish was an application on a telephone that helped people take better photographs. The difficulty was that the algorithm had been taught what a good photograph, or the machine had been taught what a good photograph as opposed to a bad photograph was, and had been trained to delete photographs where it believed individuals to be squinting. Fine. But the difficulty is the way that it identified that discriminated against certain groups of people who had different physiognomical appearances. So people who had eyes that didn't meet whatever the algorithm was trained was the right standard for an open eye as opposed to an eye that was squinting, their photographs systematically got developed. Now, the developer realized that this was an enormous problem, pulled the app. But it's a good example of the kind of bias that can happen. It's not intentional, but it's there, and it's hurtful, and it causes discrimination. And so we have to be really, really careful about that. And the last point on the AI front is I've been working in, I guess what they call legal tech for a long time, and have been constantly sold all sorts of technology that's going to solve all my problems. You buy it, you think, great, my life is going to be made so much easier, and it's the absolute contrary. The technology is never what it's represented to be. It's very different. It's extremely time consuming. It makes my life a lot more miserable. It hasn't helped anything. So how much of this artificial intelligence is marketing? How much of it is actual engineering? And is there not a disconnect right now between what we would like artificial intelligence to be and what it actually is? I think we have to be cognizant of that, and I think we have to be quite wary of it. The final final ethical question I have with respect to these technologies is their ability to exclude, not only social exclusion, but also commercial exclusion. If you think that, putting in place a full-blown data compliance program at work is quite an expensive endeavor. It requires a lot of, requires lawyer time, it certainly requires forms, it requires training. Most SMEs, many startups, just don't have the money for it. It's not a priority, and they don't have the money for it. And so this kind of heavy legislation can also be a barrier, a market barrier to entry. And so we have to, when we talk about data protection, we talk about regimes, I think we have to really be cognizant of the fact that while protecting individuals' data and their privacy is primordial, it has to be a system that's sufficiently workable and sufficiently flexible to enable small and medium businesses to comply with it. And if we really want to push it, I mean, how much of the population is dependent on small and medium businesses for their livelihood? It's high, and so we cannot create barriers to entry. The other thing that is concerning about these various technologies, they have a phenomenal ability to connect people. You think of medicine and reaching outlying regions and being able to help people. Yes, but they don't work if the infrastructure isn't there. So before we engage in all of this, we have to make sure that basic infrastructure is in place so that people who are supposed to be helped by this technology actually are helped and are not excluded because they can't participate technologically. And that leads to the third point, that for a lot of this, especially I'm using the example of tracking devices, the statistics that I've read is the tracking devices are only accurate if 60 to 70% of the population is using them. Well, if I've got serious regions or if I've got large regions that don't have access to the infrastructure, there's going to be a tremendous amount of exclusion, and my stats at the end of the day are going to be wrong. So I think we have to bear in mind that while this is very interesting, really exciting technology, and tremendous potential for this technology, there is the capacity for this technology to exclude people and to exclude businesses. And so we always have to balance both. So I'm going to conclude on that with my summary, which is as follows. AI and blockchain, I keep saying this, are extremely exciting, but they're a tremendous challenge to traditional understanding of data protection and data protection legislation and regimes. And so we have to keep moving forward. The basic principles on which most data protection legislation are based are frequently just out and out incompatible with AI and blockchain. And so what we tell clients in the absence of more clear directives is we say, okay, look, you know what, you're developing a product, try and bear in mind that there are these principles of privacy by design and privacy by default, which means try and design your product so that it respects as much as it can basic principles of data protection and of privacy. And let's try and go from there, because at least if you put that effort into something, people, the regulators will recognize that, and you will not be penalized in the same way that you would be if you've been completely negligent with respect to privacy and data protection legislation. And then I've been harping about this, but AI and blockchain are revolutionary technologies that have a tremendous ability and tremendous capacity for good, but they also have a tremendous capacity to mislead and to exclude people if we don't frame them properly, and if we don't provide some directions to where we want this technology to go. And then my final point is for artificial intelligence to develop to its full potential, what we need is accurate data. And I cannot stress that point enough, that we really have to be careful that the data we feed into these algorithms is clean and complete. So that's pretty much what I have to say today. I don't know if there are any questions and answers. There aren't. Would you like to ask? Oh, wait, I do have one. So this is a really practical one, and it's helpful. To expand a business that's in Canada to France, is it just a matter of legally updating the terms and conditions of the privacy policy, or are there other things that need to be modified on the B2B e-commerce website? That will depend. Canada has an agreement with Europe that if we're compliant with Canadian legislation, we should be able to exchange data with the Europeans. However, it would be very important to go through your site and to go through your e-commerce website, and also to go through the practices and the policies and the day-to-day of your data protection, just to make sure that it is compliant with European legislation. If you have any follow-ups, don't hesitate to contact me. And anonymized data has been touted as a means to get around privacy concerns. Any comments? Great question. And I have tons of comments, but you're absolutely right. Anonymized data has been touted as a means to get around privacy concerns. The only thing that we've found is that it is extremely, extremely difficult to truly anonymize data. And some legislation, American legislation notably, will not only say, okay, you need to anonymize the data, but I need to have a certificate that it's been anonymized. And so it's more expensive and it's more tricky than you think. It's not just a question of taking someone's name and disassociating it from other identifying factors. One solution is pseudonymization, which is you take the information and you try and make it synonymous. And that's been an easier way of saying that is functional separation. So I can talk about this more when I talk about the European Union or when I talk about marketing, but that is an excellent question. And yes, anonymized data is excluded from data protection legislation pretty much across the board, only it's extremely difficult to accomplish. Okay, I think I've cleared the questions. Does anybody else have something they'd like to add?
Yeah, I think we have another one.
Oh, yes, we do. What if anonymized data entails some personal information? The thing is that if it still has personal information, it's not anonymized. The idea of anonymizing it is so that it no longer can be traced back to a certain person. And that your question is excellent because it raises the complication of this whole thing, is that the definition of personal information is so incredibly broad that anything can be considered identifier of an individual, and that's what makes anonymization so difficult. Can you use pseudonyms for anonymity? No. No, and the European Union defines what it means by pseudonyms very clearly. It's not just a question of, oh, I messed up my anonymization. It really is a question of separating your information into different functionalities so that my marketing, the data is used differently from my client, my billing data, for instance. So it's quite a complicated process, but it's a really worthwhile one because you can do a lot more with data that is pseudonymized. I can't even pronounce that word, functionally separated, than you can with anonymous or just any data. So thank you very, very much. Nina, do you
have another one?
Right? Oh, no, that was just people being nice.
Just a comment.
Thank you.
Thank you.
So
and there's something in the chat, so let me just double check there. Your thoughts on the Turkish data protection?
My thoughts on the Turkish what?
Data protection ACT. I'm not sure if you're familiar with it.
I'm very unfamiliar with it. You know what? I've heard it mentioned once. I'd be a complete imposter to talk about it. But I can look up on it and get back to you. That's all I can say.
Thank you. Maybe we have another couple of minutes for another question. And if we don't have any more questions, then thank you so much, Danielle, for this very insightful, comprehensive
you very
overview of all the issues that we are facing with new technologies. And there is certainly a lot of food for thought here and work to do for us all to find the right solution. Right?
So thank you. And then I will be doing a few more of these, right? Yeah.
Yes, we do. Other webinars upcoming specific, right, on data protection in the EU, on data protection in the US and in Canada, where we will go a little bit deeper into specifics for each country. So thank you very much, everyone. I believe actually we do have a couple more questions there. Oh no, it's just comments. Thank you very much, everyone, for your comments, and we will see you next time on June 10th. Thank you very much.
Thank you so much. Thank you.
Have a great day, everyone.
Thank you very much, Ina. Thanks.
Thank you, Danielle. And thank you, everyone, for participating today.